Good evening to all my dear friends. As you know, we are I am taking third class on the topic Prevention of Corruption Act 1988, and everyone knows that after taking two class, I did not take seriously third class, but this class I am going to take seriously. And my main object for today's discussion is that to discuss the Kalicharan Mahapatra versus State of Orissa, which has been prescribed in your syllabus under Unit 5, that is the topic Prevention of Corruption Act 1988. As you know that I am usual to discuss the any case before and to discuss the previous year question paper. It means again today I will take 2 or 3 minutes regarding the previous year question paper, and then I will start discussing the another points. As you know that this is the best method to discuss any topic. And what is the best method? Best method is that to find out first of the question and then find out the answer. As you know that if you have certain object in that way you can get your answer in very easily. If you are not object, if you are not knowing about the questions, you can read whole the topics but you can't find out what is your answer. जैसे मैं हमेशा मैं कहता हूँ कि जैसे मान लीजिए कि हम किसी रोड पे जाते हैं, उसमें लाखों की संख्या में लोग एक दूसरे से क्रॉस कर जाते हैं और दोबारा मिले तो पता भी नहीं चलेगा कि हम कभी मिले थे कि नहीं मिले थे। मान लीजिए कोई जान पहचान का हो, अगर रोड के अपोजिट साइड से भी जा रहा हो और हमारी नजर उससे पड़ जाए तो हम तुरंत बोलेंगे अरे रुको भाई रुको रुको, मतलब एक अलग टाइप में होता है, हमारी नजर ऑटोमेटिक उसको कैच कर लेती है। तो इस तरह से हम कह सकते हैं कि अगर आप क्वेश्चन अगर आपको मालूम है तो आप थोड़ा सा भी पढ़ेंगे तो उसका आंसर आपको मालूम चल जाएगा और यही एक बेस्ट तरीका होता है। तो चलिए कुछ टॉपिक स्टार्ट करते हैं। Regarding the 218, what were the questions? As you know that if you see the previous year question paper, here the case has been mentioned. Please discuss in the light of the Kalicharan Mahapatra versus State of Orissa, which was discussed in 1998 by Honorable Supreme Court. And everyone knows that this case was decided on the 4th August 1998. But unfortunately, this is not the correct question. Why I am saying that this is not the correct question? Because here there are two parts of this question. First part says that define the public servant in the context of the Kalicharan Mahapatra versus State of Orissa. Second case is that define the illegal gratification in the context of the Kalicharan Mahapatra versus State of Orissa. Once you open original case made from the official website of the Supreme Court of India, and you will try to find out illegal gratification in that particular case, you can't find even a single word which has been used as illegal gratification. तो my point is that जो कालीचरण का जजमेंट है, आप ओरिजिनल जजमेंट भी खोल लीजिए, आप डाउनलोड कर लीजिए और वहां पे एक बार इलीगल वर्ड लिखिए या ग्रेटिफिकेशन वर्ड लिखिए, आपको कुछ भी वहां नहीं दिखाई देगा, एकदम ब्लैंक है। मतलब कि in the case of Kalicharan Mahapatra versus State of Orissa, nothing was discussed regarding the illegal gratification. So my point is that although questions you have to reply in the case of Kali Mahapatra, but you can quote another cases. That is the point. Regarding the public servant, what is the meaning of public servant? Although here we have to discuss in the light of the Kalicharan Mahapatra, I will discuss something has been discussed in this particular case. बस 1 मिनट और मैं लूंगा। स्टूडेंट्स कितना मूर्ख होता है, वो थोड़ा टीचर से कम मूर्ख होता है। अब देखो यहाँ पे क्वेश्चन ये आ गया है डिफाइन बॉर्डर ऑफ पब्लिक सर्वेंट। अब स्टूडेंट्स के दिमाग में चलेगा कि हमें इस पब्लिक सर्वेंट को सिर्फ कालीचरण के पर्सपेक्टिव में ही डिस्कस करना है। उसके दिमाग में ये चलेगा कि नहीं, हमें सिर्फ एक ही केस डिस्कस करना है और मुरारी सर जो 7-8 केस बताए हैं कि चीफ मिनिस्टर इज ए पब्लिक सर्वेंट, जजेस इज ए पब्लिक सर्वेंट, उसको कोई लेना देना नहीं है। वास्तव में रियलिटी इज दैट यस यू आर राइट, बट एट द टाइम ऑफ पुटिंग द marks you will not given good marks. That's why it is my humble request, although there is a name of only one case, but write directly and indirectly more cases. So my point is that I will discuss in this particular case public servant, and regarding the illegal gratifications nothing has been mentioned. So in another cases, with the help of another cases, I will discuss what is the meaning of illegal gratification later on. That's why here I have used in a very crystal clear wordings. Illegal gratification was not discussed in the Kalicharan Mahapatra versus State of Orissa. And this is the strong message. I have written that even these words were not used single time. मतलब यहाँ तक कि सिंगल टाइम भी ये वर्ड जो है इलीगल ग्रेटिफिकेशन यूज नहीं हुआ है. Come to the just previous year question paper, that is the 219. As you know that there are two parts of the question number 7. As you know that question number 7 is 20 marks. Question number 7 is a 20 marks. There are two parts. First part is the fact. First part is the fact, and real question. This is the real question. Whether sanction, you can say that this is the real question. You can say that this is the issue. Whatever you said that. My point is that this is the fact, and this is the questions. And the competitive exam as well as semester exam, you should always concentrate what is the facts and what is the question. एक और एग्जाम में कॉपी चेक करते समय हम लोग पाते हैं कि स्टूडेंट्स क्या करते हैं, सारी चीजें लिख देता है, लेकिन वो जो क्वेश्चन का आंसर होता है यस नो में या लास्ट में कंक्लूजन है वो लिखता ही नहीं है. तो सब कुछ डिस्कस करने के बावजूद भी जो क्वेश्चन पूछा गया है उसका अगर आंसर यस नो में नहीं करते हो या रिप्लाई नहीं करते हो, although you have discussed all these things regarding the bare provisions cases, but you will not get good marks. So this is the other points. Come to the question number 7. Whatever facts of the question number 7 is, that is the same facts of the Kalicharan Mahapatra case. My point is that whatever I am going to discuss section 7, facts, question number facts, all those are the facts of the Kalicharan Mahapatra. So come to the facts of the case. Suppose that here a raid was conducted at the residence of police officer. A question is sorry, A nahi a raid was conducted at the residence of police officer. Okay. The point is that on which particular date raid was conducted? Raid was conducted on 12th May 1990. And what was the result of that raid? Result of that raid was that recovery of cash and jewelries. Recovery of cash and jewelries. Okay. Charge sheet under the Prevention of Corruption Act, not IPC, not under the IPC. Where charge sheet was filed? Charge sheet was filed under the Prevention of Corruption Act. Everyone knows that IPC is general and Prevention of Corruption Act is special law. If you are going to file the charge sheet under the general law, the charge sheet must be filed according to the CrPC. And if you are going to file charge sheet under the special law, that charge sheet must be filed according to the special law. So my point is that here charge sheet has been filed under the Prevention of Corruption Act. Important point was that when charge sheet was submitted, charge sheet was submitted after the retirement of the accused police officer. After the retirement of the accused police officer. My point is that charge sheet was filed after the retirement. Charge sheet was filed after the retirement. Suppose that you are asking, sir, what is the fact of the Kalicharan case? I can say that what is the fact of the Kalicharan case? For the time being, forget question number 7. Fact of the Kalicharan case is that a raid was conducted at the residence of Kalicharan. Fact was a raid was conducted at the residence of Kalicharan, Kalicharan was a police officer, 1. A raid was conducted at the residence of Kalicharan, police officer, close. On which particular date? On 12 May 1990. उस केस में भी Kalicharan case में when raid was conducted on the 12th May 1990. And in that Kalicharan case, good amount of cash and jewelry were recovered. Okay. In that Kalicharan case, Kalicharan retired on which particular date Kalicharan retired? Kalicharan retired on 31st December 1990. Kalicharan was retired. Wait for 1 minute. Yes, I will discuss thoroughly. Kalicharan was retired in 1990. But here this is the May, but at that time there was a December. Here this is a 12, at that time there was a 31st December. It means Kalicharan was retired on December, raid was conducted on May, and charge sheet was submitted in that case in 1992. Charge sheet was submitted in 1992. So my point is that in the Kalicharan case, charge sheet was submitted after retirement of the Kalicharan. Kalicharan retired in December 1990 and charge sheet was submitted in 1992. So my point is that here, even in this problem, charge sheet was filed, submitted after the retirement of the accused police officer. After retirement, for example, charge sheet was submitted in 1992 and accused retired in 90. That is the fact of the Kalicharan case, as well as this is the fact of your case. What was the issue in the Kalicharan case and what is the issue in this particular case? Issue is that whether sanction is required for the prosecution of the accused police officer, whether sanction is required for the accused. So my point is that why the means is very important here. The means the accused means that police officer in whose case charge sheet has been submitted after his retirement. After his retirement, whether sanction is required for the prosecution of the retired police officer. अगर यहाँ पे द को हटाकर अगर और अच्छी तरह समझना चाहते हो तो रिटायर्ड पुलिस ऑफिसर लिख दो, यू विल बी इन बेटर पोजीशन. Whether sanction is required for the prosecution of the retired police officer, discuss with the relevant of provisions and supporting cases. The point is that discuss relevant provisions. Provisions means you have to discuss the bare provisions and supporting cases. It means your word is the cases, not the case. Word is that cases, not the case. It means you have to discuss something more cases. Only one case is not sufficient. As you know that everyone knows that I had already discussed the prevention of corruption amendment bill 2018 and again I upload that amendment. As you know that the I will answer how I will answer. This is the starting. चलो अब स्टार्ट करते हैं भाई. क्वेश्चन तो कंप्लीट हो गया. ठीक है, जाओ. Here answer of this question above problem. This is the starting. For example, this is I have written like in introduction. Answer of this question is based on the ratio of decision of Kalicharan Mahapatra versus State of Maharashtra. Answer of this question is based on the ratio of Kalicharan versus State of Maharashtra and most important point and Prevention of Corruption Amendment Act 2018. My point is that both ratio of Kalicharan and amendment law after amendment, both are just totally opposite. Both are opposite to each other. Suppose that Kalicharan is saying yes, then Prevention of Corruption Act saying no. It means just opposite, but it means whatever ratio was laid down in the Kalicharan Mahapatra case regarding the sanction for the conducting the trial of the retired public servants has been totally changed by the Prevention of Corruption Amendment Act 2018. For example, in the last, I have cited one example. In this example, वैसे तो अखिलेश हमारे दिमाग में घूमता है, इससे हमें बदला भी लेना है तो पार्टी उटी सब देता है, नहीं सिर्फ पढ़ता रहता है. नहीं दिया था भाई, भूल गया. अखिलेश तुम्हारा चूरा बहुत लाया था, बड़ा अच्छा लगा था यार. चूरा भेली खिलाए तुम, फिर आना तो फिर खिलाते रहना, तब मन से पढ़ाऊंगा. देखो इसलिए लिख दिया. बट इन दिस एग्जांपल यू आर a criminal, you are not the innocent person. For example, here that what would be fact in the fact of the Kalicharan case. In the Kalicharan case, law is something different, and after the amendment in 2018, law is different. My point is that in the last, whenever you have any confusion regarding the ratio of this case, you can read this example. It will be very beneficial. For the example, okay, take 1 minute. For the example, I want to reply answer of this question. For the example, I want to reply answer of this question. How to reply? I will take only 2 minutes. According to the Kalicharan case, पर क्वेश्चन समझ जाओ, क्वेश्चन बस इतना ही है. पब्लिक सर्वेंट के दो पार्ट होते हैं. देयर आर टू पार्ट्स ऑफ द पब्लिक सर्वेंट्स. पार्थ क्लास अटेंड कर रहे हो? पार्थ गायब?
पार्थ नहीं है सर.
हाँ आज गायब. हो सकता है कि करवा चौथ का टाइम आ रहा हो, घूम रहा होगा इधर उधर. Okay, now we will divide the public servant into two parts. First part, acting public servants and servants. There are two types of inserted note. Yes, there are two types of public servant. Wait, 1 minute. Yes, for example, I will make a table and I will discuss later on. I will improve this writing, but how to read in understand in proper manner. Public servants, for example, public servant. There are two types of public servant. Acting public servants, acting public servant. In this case, if you want to file any case against acting public servant, court can't take cognizance without previous sanctions. It means here previous sanction is mandatory. Previous sanction is mandatory. Okay. It means स्पेलिंग वाइज भरोसा नहीं है. mandate छूट गई, ये छूट गई. Previous sanction ये यहाँ पे होगा, देख लेना ना, कुछ वो नहीं है, टाइपिंग में हो जाए. Previous sanction is mandatory. Okay. On this point, every law is clear. On this point, PC Act 1947, PC Act 1988, old CrPC, yes, new CrPC, yes, and amendment, that is the PC amendment 2018. Yes, in all the laws, it is very crystal clear that court can't take cognizance against any public servant without previous sanction of the central government. मतलब हमारे कहने का मतलब है, चाहे ओल्ड सीआरपीसी हो, चाहे न्यू सीआरपीसी हो, चाहे ओल्ड पीसी हो, चाहे न्यू पीसी हो, या चाहे अमेंडमेंट हो, पांचों मिला करके एक पॉइंट पर इनका सहमति है. All the 5 laws are crystal clear and have consensus on one point. And point is that no action, no cognizance can't be taken against the public servant without previous sanctions. It means on this point, unanimity. On this point, unanimity. Unanimity रूप तो सही लिखता हूँ अभी. On this point there is a consciousness. Okay, नहीं हो पाएगा. चलो, unanimity you can read, and consciousness. On this point everyone is have unanimity and consciousness. There is no problem. But where problem starts in this case? Problem start in second part. Second part is that talks about retired public servant. On these points, each and every law has something different. Come to the point. How to discuss? For example, old PC 1947. It is silent. It doesn't say whether PC is applicable for retired public servant or not. PC 1988. It is silent whether PC is applicable to the retired public servant or not. PC Amendment 2018. This is a crystal clear. PC amendment 2018 is a crystal clear. हेलो
हेलो,
हाँ बोलिए।
नमस्ते सर, आपसे 2 मिनट बात कर सकता हूँ?
नहीं अभी बात नहीं कर सकते।
अच्छा, ठीक।
Retired PC 1947 silent, PC 98 silent, PC 2018 it is a crystal clear. It is the vocal crystal clear. It says that yes, it is also applicable to the public law. It is also applicable to the retired public servants. देखो एक्चुअली क्या है, पिछला क्लास पढ़ाया था, बच्चे इसी को लेकर कंफ्यूज हो गए, इसलिए मैं इसको इम्प्रूव किया हूँ और अपना माइंड लगा रहा हूँ। तो इस पॉइंट को तुम समझ जाना जो मैं यहाँ पे बता रहा हूँ, नहीं तो पूरा क्लास पढ़ा दूंगा समझ में नहीं आएगा, ठीक ना। बस इतना समझना है कि पब्लिक सर्वेंट के 2 पार्ट होते हैं। अगर एक्टिव पब्लिक सर्वेंट है उसमें प्रीवियस सैंक्शन भी लेना मैंडेटरी है, बिना प्रीवियस सैंक्शन के आप केस नहीं चल सकता, और उस पर पीसी एक्ट अप्लीकेबल भी है, चाहे मतलब चाहे सीआरपीसी हो, ओल्ड सीआरपीसी हो, न्यू सीआरपीसी हो, ओल्ड पीसी हो, न्यू पीसी हो या अमेंडमेंट हो, इस पर हर एक की ये कॉन्सियसनेस है, यूनानिमिटी है, इसमें कोई डाउट मत रखना। सारा गेम, सारा कंट्रोवर्सी, कई जजमेंट जो डिस्कस किए हुए रिटायर्ड पब्लिक सर्वेंट्स पर ही डिस्प्यूट है। रिटायर्ड पब्लिक सर्वेंट्स पर 2 तरह का डिस्प्यूट है। पहला डिस्प्यूट ये है कि क्या पब्लिक सर्वेंट जो पीसी एक्ट is applicable. Question is that whether whether PC Act 1988 is applicable on the point of retired public servants. Answer of some judgments of the Supreme Court, yes. Answer of some judgments of Supreme Court, no. ठीक ना, ओपिनियन डाइवर्ट है। बट इन आवर जजमेंट कालीचरण महापात्रा केस से दैट यस, इवन द this PC Act is also applicable to the retired PC. Okay, but regarding the law, these are silent. They have not clearly written. They have not clearly written whether this is applicable or not. Because I took 3 days, why I was unable to understand. This was the reason. But this is the clear. It has been expressly written here. Expressly written. Okay, this is the important point. My point is that okay, come to the CrPC. What was the provision regarding CrPC? In the CrPC, come to the old CrPC. Old CrPC means CrPC, for example, CrPC 1898. This was silent. It was silent. Okay. New CrPC. What was the section of old CrPC? Section of old CrPC was Section 197. Okay, Section 197. It was silent. Okay. New CrPC, Section 197. Section 197. Everyone knows about 1973. It is expressly written. It is expressly written, and it has used is and was. It means it is applicable to the acting, that is was, it is also applicable to the retired public servant. This is the crux of whole discussions. I will discuss on these points. Again, I want to remind here, public servants will be divided into 2 parts: acting public servants as well as retired public servant. On the point of acting public servant, every law has a consciousness. On the point of retired public servants, some law was silent, 1947, 1988. That's why there was a reason contradictory judgments were delivered by the Supreme Court. ये लॉ अगर साइलेंट नहीं रहता, अगर लॉ साइलेंट नहीं रहता तो कंट्राडिक्टरी जजमेंट नहीं आता। लॉ साइलेंट थे तो कंट्राडिक्टरी जजमेंट आते रहे। अगर आपसे पूछेंगे कि कालीचरण का जजमेंट मैं बता दूंगा, लेकिन जब 2018 और हुआ क्या था, इसी को लेकर के एक हमारा जजमेंट आता है कालीचरण का। कालीचरण के जजमेंट में भी कोर्ट ने कहा कि जब लॉ साइलेंट है तो हम इस लॉ को रिटायर्ड पे अप्लाई करेंगे। इफ लॉ इज साइलेंट, I will apply in the retired public servant also. And 2018 law was clear. In old CrPC section 197 and new CRPC section 197. It means section of both CRPC, either old CRPC or new CRPC is the same. Regarding the section, there is no any difference. Please wait for 1 minute. Charge में लगा देता हूँ. एक मिनट होल्ड करो, मैं आ रहा हूँ, रुक जाओ. Yes, regarding the section 198, 197, both the sections are silent. What happened in here? I want to take 1 minute. There was a one report, 41st report of Law Commission of India. Which report? 41st report of Law Commission of India. Suggested, it was submitted when it was submitted? It was submitted in September 1969. It was submitted in September 1999. Every in exam, they ask on the basis of which report new CRPC was enacted. Your reply will be that on the basis of report 41st report of the Law Commission of India, new CRPC is based. मतलब ये है कि जो हम लोग नया CRPC पढ़ाते हैं 1973 का, वो कैसे लाया गया, क्योंकि क्यों लाया गया, किस बेसिस पे लाया गया, उसके पीछे का जूरिस्प्रूडेंस क्या था. उसके पीछे का जूरिस्प्रूडेंस ये था कि जब 41वीं रिपोर्ट सबमिट की गई थी तो बहुत ही लेंदी सबमिट की गई थी और बहुत ही वंडरफुल सबमिट किया गया था, और उसको देखने के बाद रियलाइज हुआ कि ना अब नया सीआरपीसी से पुराना ओल्ड सीआरपीसी से काम नहीं चलेगा, न्यू सीआरपीसी को इनेक्ट करने की जरूरत है. इसी 41वीं रिपोर्ट को बेस बना करके नई सीआरपीसी लाई गई थी, और बाद में भी 1-2 रिपोर्ट आई, लेकिन वो सिर्फ सजेस्ट करती रही, मेन रिपोर्ट यही थी. इस रिपोर्ट में हुआ क्या था, व्हाट वाज रिटेन इन दिस रिपोर्ट? इन दिस रिपोर्ट, Law Commission of India suggested that old CRPC, this particular CRPC is silent. It is not protecting to the retired servants, officers. This is not the good law. It means whatever provision of the old CRPC was criticized by the commission, and on the basis of नहीं चल रहा है. On the basis of this report, 197 was inserted and it was amended, and by this section both types of officers, where public or private, are covered. Okay, this is the brief. Come to the point. Come to your question. What is the questions on this point? In this case, point is that here answer of this question is based on the ratio of Kalicharan and Prevention of Corruption Amendment Act. Answer of this question regarding sanctions can be divided into 2 parts. Regarding sanctions can be divided into 2 parts. These are, see, in the Kalicharan case, it was said that previous sanction is not necessary. See here, it was said that previous sanction is not necessary. But after retirement, this law said that previous sanction is necessary. See the difference between both. It means if I am going to reply answer of this question, I will say that on the basis of the Kalicharan case, there is no need of the previous sanction to prosecute the accused police officer. But if I am going to reply according to the Prevention of Corruption Amendment Act, I have to say that no, even in this case, previous sanction is necessary. मतलब एक लाइन ये हुआ कि इसका क्वेश्चन का 2 आंसर होगा. इस क्वेश्चन 7 का क्या आंसर होगा? 2 आंसर होगा, एक आंसर होगा नो और एक होगा यस। अगर हम कालीचरण के केस में का लेकर रेशियो कहेंगे तो हम कहेंगे कि इस तरह के करप्ट पब्लिक सर्वेंट पर केस चलाने के लिए वो रिटायर्ड हो गया है, रिटायर्ड होने की वजह से उस पर हमें प्रीवियस सैंक्शन की जरूरत नहीं है। तो कालीचरण के रेशियो के हिसाब से इसका आंसर आएगा नो। ओके, लेकिन अगर 2018 के हिसाब से अगर हम इसका आंसर निकालेंगे कि 18 के बाद के अमेंडमेंट के बाद क्या आंसर आएगा, इसका आंसर आएगा यस। अब देख लो, एक ही क्वेश्चन का 2 आंसर है, इसका नो भी आंसर है और इसका यस भी आंसर है। जैसे कि एग्जांपल मैं लेता हूं यहाँ पे, एक लास्ट में देखो, कल भी क्लास पढ़ाऊंगा, आज तो मैं समझ रहा हूँ कि जैसा भी पढ़ा रहा हूँ कोई वो नहीं है। अब कंक्लूजन के बाद एक एग्जांपल लेते हैं। फॉर एग्जांपल क्लियरली शो दैट अखिलेश वाज ए पब्लिक सर्वेंट, ही वाज द पब्लिक सर्वेंट। इंपॉर्टेंट पॉइंट वाज दैट ही वाज द, एक मिनट, he was the public servant. Public servant means section 2C of the Prevention of Corruption Act and section 21 of the IPC. But he is charged under the Prevention of Corruption Act, that's why he 2C. He was the public servant of which government? He was the public servant of central government. Okay, and he was in service during 2000 to 2020. 2000 to 2020. He committed corruption in 2018. This is the most important point. When he committed the corruption in 2000, he committed corruption in 2018. यहाँ करेक्शन होगा भाई, थोड़ा सा गलत है। अखिलेश थोड़ा सा इसको नोट डाउन कर लेना, तो करेक्शन होगा, ये 2018 ऐसे लिखाएगा, ठीक ना। चलो, तो he committed corruption in 2018. Okay. Come to the point, इसमें भी करप्शन हो जाएगा। Come to the point. If trial, what is the effect of Kalicharan? See, the facts are both is same. Fact of this point and this fact problem is same, but answer will be different. See, the problem is same, and suppose that trial started in 2019. Trial started in 2019. It means he was the acting public servant. He was acting public servant. Okay. In that case, previous sanction of central government is necessary. No problem. Everyone knows that he is the acting servant. Previous sanction of central government is necessary. Okay. According to the effect of amendment, here 2019, it means acting servant. Even in this case, previous sanction of central government is necessary. So my point is that on the point of acting servants, Kalicharan case and amendment both have same decision, no changes. Come to the second point, retired officer. यहाँ पर भी गलत हुआ, यहाँ पर भी थोड़ा सा ईयर का भी गलत हुआ, नहीं ईयर सही है इसका। Suppose that second part, that is the retired officer. ये पार्ट हो गया हमारा रिटायर्ड ऑफिसर का और ये पार्ट हो गया रिटायर्ड का, इसी पर डिफरेंस आएगा। सपोज दैट अखिलेश वाज चार्जशीट वाज सबमिटेड लेटर ऑन एंड ट्रायल स्टार्टेड इन 2018. 2018 मींस आफ्टर हिज रिटायर्ड, बिकॉज ही रिटायर्ड इन 2020. In that case, previous sanction of central government is not necessary. According to the effect of Kalicharan case, this answer is not necessary. But come to the Amendment Act, it is necessary. See the difference between both. According to the judgment, previous sanction is not necessary. According to the after the amendment, previous sanction is necessary. So it is my humble request, in the time of examinations, always write latest law. It means you have to discuss Kalicharan case as well as effect of this particular amendment. It means if you are not going to discuss this amendment and you are discussing only the Kalicharan case, you doesn't deserve for the good marks. With the help of this example, you can get some clue. And now I will start cases from the very beginning. मैं समझ सकता हूँ तुम लोग थोड़ा सा प्रॉब्लम हो रही होगी, मैं भटक रहा हूँ इधर से उधर। हाँ बोलो
सर, ये जो आपने भी बताया अमेंडमेंट जो किया है 2019 तो सर्विंग 2018 में जो अमेंडमेंट किया है,
हाँ
तो सर 2019 जो ट्रायल इन 2019 है, इसमें जो सर्विंग पर्सन है उसके लिए सेंट्रल गवर्नमेंट का सैंक्शन नॉट रिक्वायर्ड है।
नहीं, अगर एक्टिंग अगर रहेगा, अगर
हाँ,
एक्टिंग रहेगा तो सैंक्शन गवर्नमेंट सैंक्शन मैंडेटरी है।
दैट्स व्हाट आई एम आस्किंग सर कि सैंक्शन तो मैंडेटरी अगर वो एक्टिव सर्विस में है तो।
यस, तो हम भी तो एक्टिंग का तो वही लिखे है ना, एक्टिंग का तो कोई डाउट ही नहीं है। देखिए, लिसन मी 1 मिनट हियर, दिस इज द एक्टिंग पार्ट, this is the acting part, okay? On the acting part I have written here that previous sanction of central government is necessary, okay? Come to the second point, previous sanction of central government is necessary, okay? So my point is that on the acting point nothing is changed, both are the same. See?
Yes,
okay?
correct.
And that's why I have taken cut paste. That's why I have not written another language. Even I have taken cut paste. There should not be any confusion. My point is that we have to discuss only on the point of retired public servants. What is the position regarding the retired public servant? Question is that whether in the case of retired public servant, previous sanction is necessary or not. Okay? According to the Kalicharan case, previous sanction is not necessary. But after the amendment, it said that previous sanction is necessary. It means ratio of Kalicharan case has been overruled by the amendment 2018. Because see, here see the year, Kalicharan was decided in 1998. Law has been amended in 2018. Earlier it was saying that not necessary. At present time it is saying necessary. It means in one line we can say that ratio of Kalicharan case has been overruled by the CrPC amendment 2018. सही है?
हाँ सर, अभी ठीक है।
चलो, है ना, तारीफ सुनने के लिए तो पढ़ाते हैं, और क्या, पागल थोड़ी हैं।
बट सर इसकी रीजनिंग क्या है सर? बिकॉज अगर
ना अब बस करो, रीजनिंग में पहले डिस्कस कर चुका हूँ। प्रिवेंशन ऑफ करप्शन एक्ट का जब अमेंडमेंट जिस दिन डिस्कस किया था उस दिन का वीडियो देख लो। और वैसे तो मैं रिप्लाई किसी का नहीं करता, तो मैं थैंक्स कहना चाहिए कि आपने रिप्लाई कर दिया। चलो अब आगे पढ़ते हैं।
ओके सर, ठीक है, थैंक यू।
कम टू द पॉइंट। इसके ऊपर लिखा हो तुम पढ़ लेना, बहुत इजी है, बहुत कुछ है नहीं। कम टू द पॉइंट हियर इज दैट here I have also made chart here old days, you can read, no problem, okay? Here the in the new CrPC, what is or was. Is means acting public servant, was means retired public servant. Here in 19 PC Act, word is the acting but was is missing, the law is silent, okay? Neither it includes nor excludes. Kalicharan case, it was said that applicable even to the retired public servant, Kalicharan. After the amendment, this is the positions. Come to the Kalicharan Mahapatra versus State of Orissa. This is the very important judgment which I have to discuss. And if you see that this case was decided by Honorable Supreme Court, judgment was written by the Honorable Justice K.T. Thomas, and case was decided on the 4th August 1998. As you know that every time I try to write the date of the judgment. Why? Because you can search original judgment from the website, from the Supreme Court of India, and you can read yourself and you can check whether I have written wrong or right, and you may also suggest me. Summary is very important for the understanding. As you know that, first of all, I will discuss the facts of the case. Later on, I will discuss the issues, and after that arguments of the appellant and respondent, and some statutory provisions which are involved. For example, in this case section 2C was also discussed. 2C means define the public servants. As you know that the previous year question has been asked. I will discuss section 13(1)(e) of the PC Act, because the charge sheet was submitted under this particular sections. Okay, and section 13+2 talks about the punishment for causing like this. Now here these are the sections which talk about the uh, previous sanctions, previous sanctions, previous sanctions, previous sanction. It means here there is a 1947 old PC, 1898 old CrPC. So what was the provision in the old PC? Old PC, which sections deals about the old section 6 of the old PC was discussing about the previous sanctions. Okay, I will discuss. You may ask, sir, why you are discussing the repealed provision? We are in our syllabus PC Act 1988. Why you are discussing the old provision? What is the benefit? So my point is that Section 6 of 1947 is the parliamentary of Section 90 of the new Act. मतलब parliamentary मतलब सिमिलर होता है, एक लैटिन वर्ड है. तो सेक्शन 6 में जो बातें लिखी गई थी ओल्ड सीआरपीसी में और ओल्ड पीसी में, उसी बात को सेक्शन 90 में लिखा गया है. अब हम क्या करेंगे कि सुप्रीम कोर्ट के कई जजमेंट पहले डिसाइड हो चुके हैं ओल्ड पीसी पे, तो हम उन्हीं ओल्ड पीसी के जजमेंट को यहाँ पे कोट करेंगे. जब हम यहाँ पे डिस्कस करेंगे तो सम मोर केसेस आई विल डिस्कस. फॉर एग्जांपल एस वेंकटरमन केस, के वीरास्वामी वर्सेस यूनियन ऑफ, ये जो केसेस हैं वो ओल्ड पीसी के हिसाब से डिस्कस हुई हैं. तो हमें क्या है कि न्यू पीसी को समझने में सही पड़ेगा और इसको हम जजमेंट में कोट भी करेंगे. So my point is that here the old PC, section 6, section 19, new PC, and section 197 of the old CrPC, section 41st report of the Law Commission of India, and here this is the new CrPC, new section like this. And I will discuss all the 8 statutory provisions, and it will be helpful for you. And after that, I will discuss ratio of this particular judgment, as well as ratio of some another judgment, that is the, for example, S.A. Venkataraman versus State and K. Veeraswami versus Union of India and others. And everyone knows that in the previous classes, I told you that in the K. Veeraswami versus Union of India, Honorable Supreme Court held that judges of Supreme Court and High Courts also come under the definition of public servant, and against them, cases can be started under the Prevention of Corruption Act. And in that case, who will give the sanction? अगर मान लीजिए सुप्रीम कोर्ट की जज पे अगर इस एक्ट के हिसाब से अगर आपको केस करना हो तो सैंक्शन कौन देगा? क्योंकि he is a public servant. In that case, president will give the sanctions. Okay, I will discuss these 2 more cases, S.A. Venkataraman cases like this and Veeraswamy cases. And after that, I will discuss the decisions, conclusions of these cases, and then I will start the facts. So my point is that now I have to start the facts. And मुझे मालूम है कि लगभग टाइम खत्म हो चुका है और 6:30 बजे का टाइम है, शायद खत्म हो चुका है. अब नेक्स्ट क्लास से हम लोग प्रॉपर वे में इस टॉपिक को स्टार्ट करेंगे. And it means today was the introduction class on this topic. In the next class, I will discuss